that context,
that's the concurrent list where the provincial assemblies. You see, the problem of saying what you are saying is in relation to 192. Law means act of parliament. Is that it then relates to entry 58, and entry 58 says anything which is in the competence of parliament or relates to the federation.
Yes.
Is exclusively in the federal domain. Provinces can't make any law. Now, surely a province is entitled to say, well, sir,
we need more judges.
No, we need more judges. That a high court, it may be a matter relating to the federation, but it also relates to a province. How can you relate law over there as act of parliament, read it with entry 58 and just wipe us out of the picture? No, but वकील साहब,
मैं इस पे आगे आने लगा हूँ ना।
इसमें एक मुश्किलात है ना। अब सवाल ये उठेगा, अगर दोनों हैं तो फिर कंकरेंस है तो फिर पैरामाउंसी है। देखिए, जो क्वेश्चन दैट माय बात सुन लें, द क्वेश्चन दैट माय लर्नेड कॉलीग पुट टू यू, वन साइज फिट्स ऑल नहीं चल सकता यहाँ पे। यूज ऑफ द वर्ड लॉ कैन हैव सो मेनी शेड्स ऑफ मीनिंग। तो आप जरा
इसको हम एड्रेस कर लेते हैं। इसको इट्स इजीली एड्रेस।
इसको कर लेते हैं। मैं आई एम जस्ट पॉइंटिंग आउट द डिफिकल्टी।
I thought about it that why can't mean an act of provincial assembly, but that need not detain us for the purpose of Article 191, because there the Supreme Court is exclusively outside of this.
Yes.
So therefore, for the purposes of 191, there is a confusion here. I thought about it, but then I stopped thinking about it for that matter, because 191 के लिए relevant नहीं था. But in any way, in any event, it would be an act of parliament, or.
Why don't you say it is intentional by the framers of the Constitution that one place it is by act of parliament, surely there it could not be by law. So we are agreeable there, I hope. And the other one, the parliament kept the door open, whether it would be parliament itself or it would be the provincial assembly, without fixing it, because maybe the framers of the Constitution wanted to make the Constitution a living, breathing organism which can, depending on the situation at that relevant time, and if they have put Act of Parliament, then it would have fixed it and Provincial Assembly would have gone away. Or if they have put Parliament or Provincial Assembly, they may not have wanted to do so. So sometimes ambiguity is intentional. It is not that they made a mistake or didn't think about it. I would consider that if they use the word law there, we don't need to address that in this case, but it is the only thing which comes out clearly is that the first one is fixed by the parliament and the other one by law, which could surely not include judge-made law.
And
I would think that would be a stretch if we say, no, it could also include judge-made law.
And
I don't know.
If I may, it should surely be an act. We can debate which assembly or the parliament, that we can park it aside for the purposes of these proceedings. But what it surely does is that for the purposes of Article 191, an act of parliament cannot be excluded.
It's the context which has to be seen. The context is relevant. I think the language is used in context. The words should don't mean, the same words can mean very different things used in different contexts.
So, yes. The point that I'm trying to make through this is that an act of parliament is included, is covered in the meaning of term law in 191. Yes. 191. Now, before
Attorney General, you were just referring to 192, and you said the word law is used here, but देखें उसका context क्या है? The High Court shall consist of a Chief Justice and so many judges as may be determined by law. ठीक है? अच्छा, अब उसको आगे क्या उन्होंने qualify कैसे किया? Until so determined. इसमें क्लियरली इंटेंशन है कि जी लेजिस्लेटिव कॉम्पिटेंस वो दे रहे हैं कि आप जब तक वो लॉ नहीं बनाते तो प्रेसिडेंट डिटरमिन करें. There is no such phraseology used in 191. It doesn't say until such law is made.
There is a reason for that.
Yes.
The reason is because in both 1962 and 72 the identical language appeared, And when 93 constitution commenced, we already had the rules. So there was no reason for anyone to determine anything because there was already something in existence.
No, so obviously
this situation
इसमें ये कहा जा सकता था ना, अगर ये intention थी कि जी the Supreme Court may make rules regarding regulation of procedure and practice until law is made or a law is promulgated. ठीक है, उसमें आप लेजिस्लेटिव कॉम्पिटेंस कन्फर कर रहे होते कि जी सुप्रीम कोर्ट अगर रूल्स बना भी लेती है तो आप अगर कानून बना देते हैं तो इट वुड ओवरराइड दोज रूल्स. Now that intention is neither explicit nor implicit in the language of 191.
My lord, my respectful submission is that it is not so.
जहाँ उनकी इंटेंशन थी कि जी लेजिस्लेटिव कॉम्पिटेंस ग्रांट करने की, वहाँ उन्होंने लेजिस्लेटिव कॉम्पिटेंस एक्सप्रेसली ग्रांट की है.
My lord, I'm going to come to that, but let me first address the question that you had previously raised, and let me just deal with it because when we look at the term law, we have to give it some meaning. Some meaning to it. I have submitted that there could be two meanings to it. One meaning is an act, other meaning is a binding precedent. I'm going to deal with it when I address the question of convention. But let me first take care of the 1956 rules being existing law and then proceed with it.
Do you have attached the rule 1956 in your paper book, 1956 rules?
My lord, this may kindly be recorded, my lord. This is something that I thought about later, so this may kindly be noted. Now, clause 7 of article 268 does include within its meaning rules, bylaws, regulations as existing laws. And then clause 1 of article 268 tells us how they shall be dealt with under the new constitution. I'll just read out 268 clause 1 and then take your lordships back to 191 and then the rules of 1980. Clause 1 of article 268, it says, except as provided by this article, all existing laws shall, subject to the constitution, continue in force so far as applicable and with necessary adaptations until altered, repealed or amended by the appropriate legislature. Identical language in 270AA6, which deals with anything and everything that had happened prior to omission of or concurrent legislative list.
Sorry,
after the 18th
I'm not following it. Are you saying that Article 268(1) saves laws which existing laws which it goes on to define in subclause 7, but specifically excludes decisions of the Supreme Court or the High Court? Are you saying that?
No, what I'm saying
but
is...
this definition of law does not say and decisions.
मैं अभी उस पे आता हूँ सर. मैं यहाँ पे ये कह रहा हूँ कि जो existing laws थे उनको save किया.
But when we're using the term law, because sometimes you say it includes decisions. So, but this article does not mention.
Independent of my earlier submission, मैं यहाँ पे उस point को address कर रहा हूँ जहाँ पे my lord की observation थी.
नहीं मैं वो बातें नहीं, मैं आपसे standalone सवाल कर रहा हूँ. मैं ये कह रहा हूँ कि does this mean that this is the starting point and we are not, the courts are free of earlier judgments because existing laws does not specifically mention decisions of the superior courts or of any courts?
उसमें my lord perhaps 189 का effect.
No, perhaps नहीं, मगर
189
अगर आपका law आप उसको extended meaning दे रहे हैं तो यहाँ आप उसको restricted meaning दे रहे हैं.
Provisions which survive will
existing laws की definition दी हुई है जी साहब.
The provisions
existing laws की
judgments का तस्करा नहीं आ रहा है ना.
नहीं आ रहा ना. उस 7 में definition पढ़ लीजिए आप.
उसमें ये होगा definition
existing laws की.
जी.
Sub article 7 पढ़ लें.
जी.
In this article, existing laws means
all laws including ordinances, orders in council, orders, rules, bylaws, regulations and letters patent
शायद इसलिए भी
constituting
ना
a high
कि
court and any notification.
Attorney General, this is a saving clause, so they could not have referred to the judgments. It is a saving clause, could only deal with laws.
Laws, and so long as those laws continue, the effects of the
Why are we
judgment.
categorizing it as a saving clause?
My lord,
No, tell me from the text, why are you categorizing it as a saving clause?
my lord, this is giving continuance to the laws which were in field.
No, but
because,
if you read it with sub-clause 1,
Ji.
it is nothing saving about it.
no, what it is doing is, it is in order to ensure the continuity of system. It is
Part of the
permitting those laws to
if that
continue
is the
till such
argument,
time.
if that is the argument, then continuity of the system surely requires judgments to be sustained as well.
मैं उसकी जरा थोड़ी सी ये submission complete करूँ, ये confusion clear हो जाएगी.
Okay.
Let me just complete my submission. My lord, my submission, and then let me just now state what my submission is before I come to explaining it. My submission is that the term law used in 191 cannot possibly include 1956 rules. And I say this because if
Existing laws did not include.
the term law in 191 as used in Article 199 cannot include 1956 rules. This is the observation, this is an observation made by my Lord Justice.
Kindly repeat that, I'm
Yes.
missing it.
The
1956
term law used in Article 191 does not include
1956.
an existing law, which is to say the rules of 1956, the Supreme Court rules of 1956.